Hi, my name is Mona. I work at Forbix. We're in Calabasas, and I am a residential private money and commercial lender and broker. And today I'm talking to Matias, who is a real estate agent specializing in probate and trust sales. So, Matias, tell us a little bit about yourself and your background.
Thank you, Mona. It's good to be here. Thank you for pronouncing my name correctly. I appreciate it. Some people say Matias, some people say Mateus, but you said it right, Matias. I was born and raised in Italy. I've been in Los Angeles since 1999. So I consider myself an Angelino. As you mentioned, I am a real estate agent who specializes in trust and probate. I am with Berkshire Hathaway, with the Sanborn team, and we have a very long tradition of handling trust and probate real estate, as well as conservatorships. We do standard real estate as well, so your regular sales, but we are really carved a niche for ourselves in that environment.
Tell us, what is trust and probate real estate?
So the short answer is that, I in a kind of like a tongue-in-cheek way, I always say, like, I represent dead people, because there's a lot of truth to that. I represent a lot of people that are vulnerable, in a sense that, so generally trust and probate real estate or conservatorships, well, specifically trust and probate, happen when somebody passes away. In the state of California, if your property is in a trust, then it's a trust sale. If your property is not in a trust, then if you just have a will or don't have a will, then it goes through probate. Now, probate is regulated by the state law, the California Probate Code, and there are specific requirements that need to be met in order for a sale of an asset such as real estate. And when it comes to a trust sale, a trust is a private document, so there is a lot less. There is no court oversight. But there are nonetheless requirements, and some complex trusts have things such as notices of proposed action, et cetera, et cetera. Now, when it comes to a conservatorship, on the other hand, that's when somebody is incapacitated. So you can imagine somebody in an advanced stage of Alzheimer or with Parkinson's disease that is unable to look after their own affair. And in that case, a conservator is appointed to oversee the affairs of the conservatee. And we help during the sale. A lot of the times, there's people that are appointed, can be professional fiduciaries. Sometimes they're family member. And in this area of real estate, there's a lot of, as you can imagine, elder abuse, et cetera, undue influence. So what basically we do is make sure that the interest of the beneficiaries and in the interest of the seller are protected through this, through a series of check and balances that we put into place over the years. We work mostly with attorneys, which are estate planning attorneys or probate litigators, as well as elder law professionals, and like as I mentioned, professional fiduciaries. A lot of our clients are professional fiduciaries, so that's kind of the type of clientele that we deal with. And of course, the family is always in the forefront. It's always somebody that we're helping. We're trying to get the most return, as well as managing risk, which is extremely important in this type of sales.
My next question, which is, how would this differ than a regular sale? Because you said managing risk.
Mm-hmm.
And I would imagine that managing risk is the way that you would lead into how this is different from a regular sale. Not to say that
Absolutely.
You would manage risk in any other sale, but in this case, you're dealing with fiduciaries, attorneys, beneficiaries, etc.
There are definitely differences between a standard sale. Some of the examples that I could give you are the statutory differences. For instance, when the personal representative, whether be a family member or somebody appointed by the court, has limited authority, the court has to approve the sale. So some of the things that are different is that every county is a little bit different, but in Los Angeles County, the minimum deposit is 10%. So when you do your most real estate sale, you're familiar with the 3% earnest money deposit, right? That's what we call the way you show you're serious about real estate, right? You put 3% in escrow. Well, in this case, it's 10%. Furthermore, the offer, in order to petition the court for a confirmation of sale, the offer has to be non-contingent. So all the familiarity you have with appraisal contingency, inspection contingency, and loan contingency, these are the three big ones. All of those have to be taken care of prior to submitting the offer. To submitting the request for confirmation of sale to the judge, essentially, to the probate court. So
right there. So someone can make an offer, give you the 10% EMD or earnest money deposit, and do their due diligence. But then before you go to the court, those contingencies have to be somewhat met before you go to the court.
So that's not how we do it, but that is a way to do it, but it's a very risky way to do it. We don't do it that way. So when I talk about managing risk, I mean, we list the property, we leave it on the market about 10 days, and this will give an opportunity to anybody to do their due diligence prior to submitting an offer. When we get the offer, it's a non-contingent offer. The 10% deposit, the money goes hard on day one. It's non-contingent. So they can back out. And this is important because you don't want to be held hostage. You don't want the estate to be held hostage in a position where they have to give credits, where, something's happening and you petition the court and then you have to change the sale price amount. You don't want any of that. So we kind of, this is very unique. Not very many agents do what we do. Everybody does their due diligence before. And we just basically give everybody an opportunity. So we do all the disclosures prior. So imagine, instead of ordering a preliminary title report, which is, people that are not familiar, but that's, the insurability of title by a title insurance company, ordering a city report. In the city of LA, you have an INA report. In Inglewood, you have a city of Inglewood report. Every city's got their own requirement. A retrofit requirement that may be necessary. We do all of those things prior to the client, to the buyer submitting an offer. So there's a lot of work that goes in prior to putting the property on the market. Once the property hits the market, we have all the disclosures, we share them with everybody. And we say, look, do your inspections, do your everything. Just make sure you go in with your eyes wide open. And furthermore, obviously, any material fact that the seller is aware of has to be disclosed. Now, keep in mind that some of the people we work with have never been in the house. They've never seen the property we're selling, right? A professional fiduciary may have never seen the home, or a successor trustee who could be an adult child, maybe living in New York and their parents passed away in LA. Maybe they haven't lived in that house since they were teenagers, right? So in California, there's an exclusion. It's called exempt sellers, and you're familiar, I'm sure, as a real estate professional. We call it with the exempts instead of the TDS and SPQ, which are statutory. From California code, you have an exemption in this case, where you can only disclose. You have a limited amount of disclosure, and that's what I can't stress that enough. That's what it means to manage risk, to make sure that our clients are not put in a position where they have to disclose things that may open up the proverbial can of worms. Does that explain? So that's just part of it. Because I could talk about this stuff all day long. So that's just the beginning. That's just scratching the surface, because then you have statutory requirements like notices of proposed action, right? So if you're not confirming in court, you have a trust. Sometimes trusts require notice of proposed action. What is that? That is the seller, so the successor trustee, is telling all the beneficiaries and all the party involved, this is the action I'm going to take. You have X amount of days to object, right? If they decide to object, then several things can trigger. In the case of a probate, if the personal representative has full authority, but somebody objects, they have 15 days by statute. Somebody objects, and they say, you know what, I don't agree with what you're doing. I don't want you to sell the house. I want you to be removed as the personal representative, or whatever the list of things. I want to sell the house. I want my uncle to buy it. I don't know. It's not enough money. It doesn't matter what their objection is. There is a legitimate objection. Then it triggers in that there needs to be court confirmed, because you have an objecting party, and then you have to to. So by specializing in these things, what you're doing essentially, you are protecting the attorney, number one, which is sending you the business because they are working on the interest of their client, right? And number two, which is more importantly, obviously, sorry for the attorney, is that you are protecting the seller, the personal representative, from liability. If they could get sued from a beneficiary or whatever the story may be. I noticed that. Did you have any specific questions, Mona, that you wanted to talk to me about? I noticed that you had.
Well, to the transaction, because it sounds to me, because you don't want the buyer to come back later and say, you should have disclosed A, B, C, or D if it turns out that the successor trustee or whomever it is out of state or out of the country, right? And didn't know. So there's that. And you're also helping the attorney with managing risk, et cetera, because you want to make sure that the all the court confirmations, everything goes through, so that none of the beneficiaries can come back later and say, you know what, you got rid of my share, you didn't tell me, I didn't get notice, or you should have sold it for a lot more money, whatever the case is.
Exactly. And part of the process is as well on our end, we have to keep meticulous records of the efforts that we make, because you want the successor trustee or the personal representative, if they are ever challenged, it's very rare, but if they are, to show, look, we kept it on the market. Look, we did internet advertising. We did this. We received 7 offers, because there's always somebody can think like their house, it's worth, 3 times what it's actually worth so you got to show like, look, this is what the market, this is the best we could do. And something that we do as well is that we encourage. So as you know, when a probate is under limited authority, there is an opportunity to overbid the purchase price in court. So that's like an auction. So what we do when we have the court date, we continue to market the property. So that, and often it happens, people show up in court and they can pay even more. There's a calculation. The easy way to figure it out is to do, it's 5% over the original bid plus $500, but it's not exactly that. It's actually 10% of the first $10,000 and then 5% thereafter. I don't know why, that's a little bit of an old way of calculating it, obviously, because that $10,000, maybe that was good probably when houses cost around $10,000, but we know in our market that's not the case, far from it. So yeah, that's it. Like you want to make sure that you show the effort that you've made to market the property and that you present the property in the best possible light without putting the seller in a position of being held hostage, essentially, by unscrupulous buyers, which are out there. Obviously they can say, oh, there's a leak in the roof, now I want 50,000 discount, this and that. And we avoid all of that from years and years of experience that Sanborn team has had in dealing with this type of sales. And frankly, like the results that we get are very well accepted within the the trust and probate community.
And because I was going to ask you what your primary source of referrals, but I believe you said fiduciaries and successor trustees and
attorneys really is the core of the referral business. It's probate attorneys, which like probate litigators essentially, as well as estate planning attorney, which are the people who write the trust, as well as trust administrators, which are usually overlapping estate planning attorney and trust administrators. And then we go in the realm of professional fiduciaries who have been appointed either by the court or have been appointed as a neutral third party, sometimes as a conservator, sometimes as a successor trustee. The bigger the estate, the more convoluted it is.
I've worked with fiduciaries before, and it's usually when there's some kind of infighting or somebody doesn't have capacity, and then the court puts in a fiduciary to say, okay, manage the affairs or the real estate affairs. And you're right. I don't know if a lot of these folks see the property or anything like that.
Right. And also, when you're absolutely right, when there's a challenge, when somebody, let's say, there's several siblings, and one is the successor trustee, and they say, well, we don't want you to be the successor trustee. We're gonna, when the family tries to remove the successor trustee or remove the personal representative, generally speaking, attorneys have a tendency to go to a neutral third party, which happens to be a professional fiduciary a lot of the times.
Right. Yeah, that's where that comes in. So do you have any advice for somebody who's looking to get started in this business?
Yeah, I think that if somebody is interested in starting this business, my advice is really to find somebody who does it. It's important in a lot of businesses, and this one is no different, in a sense that you want to find somebody who's been doing it for a long time. And sort of in Italian, we have an expression. It's a andare a bottega. Okay, bottega is like a little shop. So imagine this: you learn from the master. Let's say you want to start, making violins, right? You're not going to get in your basement and say, okay, I'm going to learn how to make violins, right? No, you go to a master violin maker, mastro, and you learn from them, and you go to their store and you apprentice. So I think it's extremely important. And you know what? In law is the same thing. When people come out of law school, I hear most of the attorneys are clueless in the sense that like they don't know what they want to do. So you go to a firm that is somebody who,
I'll tell you, in law school, because I'm an attorney also, I don't practice. They give you enough to pass the bar. That's the job, to go through law there. Graduate, pass the bar, and then after that you work. And then when you work, you get you get the experience, because the reality is, let's say you have somebody who wants to practice criminal law. Criminal law might be like 3 or 4 classes if you take an elective, right? That's not enough. So, yeah, same idea, but sorry, go on.
No, absolutely. That's the point. That's the point. So if you want to get started, find somebody who does it well, and ask them, I want to learn. Can I help with this? Can I help with that? And then that essentially is the way to do it. I know that now the California Association of Realtors has a certification in trust and probate sale. I took it for fun, I guess, because it's a new thing. It's been out I guess a year or so. It gives you the basic, but it's far from the need. It gives you enough of the information so you can kind of talk about it, but it would, I wouldn't go out there just with that kind of information and try to, succeed.
It's like taking your real estate test.
Yes.
Because I have that license too. You take the test, and then they'll ask you about, I don't know, they'll ask you about zoning and, lines and, border lines and things like that. But then you're like, no, this stuff doesn't come up. Maybe one question is relevant all year long, right?
Right. There's a lot of truth to that. Yes.
It's just enough to pass the test, and then you practice, like you said, your bodega reference.
Yeah, exactly. Andare a bottega. There's no substitute for that.
So tell me, what areas are you active in? I know you said that you're in Beverly Hills, but what areas of, Los Angeles do you specialize in?
Because of the nature of my business, we cover all of Los Angeles County, some parts of Southern Ventura County, and some part of Northern Orange County. And that's pretty much our area of focus. I sell anywhere from Simi Valley to Long Beach daily, from Malibu to Pasadena and everything in between. I can't tell you, if you look me up on Zillow and you look at a map of where I sell, you're never gonna, I'm not a neighborhood realtor because of the nature of the business that I do. And this, I love this because it gives me the opportunity to go and learn. And I kind of I've said this over and over again. So if people have seen other interviews that I've done, they may get tired of it. But I have a love affair with the city of LA. And I absolutely love going into different neighborhoods and learning.
Sort of as an aside to that, I've been getting these pictures on social media about what Los Angeles looked like in the 20s. So they'll have a picture of Hollywood Boulevard, right? Like 1920, nice. And then today, and it's like you put them together. And I just say, God, who would have ever known? Everything was so cheap back then. Only knew.
A lot of truth to that. Absolutely.
Only you. So if somebody wants to get a hold of you, what's the best way?
The best way to reach me is via email, probably. You can check out the website. It's super easy to remember. probaterealtor.la. probaterealtor.la. And my email is mm@everyla.com, everyla.com. You can call or text me at 310-776-5145. 310-776-5145. And what I tell people all the time, what I do, generally speaking, should not be done by an inexperienced, realtors that you happen to know or your neighborhood realtor. But if you are adamant about using somebody who doesn't have experience in this world, I would suggest reaching out anyway, because a second opinion doesn't cost you a thing. And I love what I do, so reaching out with questions, and I love to help people, even if they end up not working with me, that's perfectly fine. It's never wasted. I always enjoy pointing people in the right direction.
Oh, and then really, really quick, just in closing, you also have a podcast.
I do. The Probate Realtor Show. Thank you. Feel free to it's on Spotify, it's on Apple Podcast, it's on Amazon Music, it's on YouTube. The Probate Realtor Show, and it's full of information. And obviously, if you go to probaterealtor.la, you can find all the episodes. It's really, really interesting, and we talk about things like doing estate sales. What are beneficiary rights? What are fiduciary rights? What is a trust sale? What is a probate sale? Like really, really valuable information provided free of charge. Obviously, it can help anybody who needs more information, or if they find themselves in a situation of experiencing a loss, and then you have to deal with a lot of things. I know you have plenty of things on your plate when that happens, so hopefully we'll be able to alleviate some of the burden that comes with dealing with this type of sales.
Well, I think the cool thing about that is, because I got a chance to take a look at it, is that you interview a lot of industry professionals.
Yes.
And it's very detailed, and it's the type of thing. I mean, obviously we do what we do every day, so we know what escrow is, we know what a title report, things like that.
Right.
People who are doing this only a couple of times ever, they don't even want to deal with it, right?
Right.
So if they want more information, they can listen to your podcast, because you're talking to a lot of different industry professionals.
Yes.
And the other thing that I think is super cool is it creates like a think tank environment, right?
Right.
If you're interested and have a question about something quirky that might come up on a title report, you have a title officer or escrow, you're not sure how to do a distribution, or maybe you're talking to an attorney about something specific with conservatorship. And so it creates this really nice community that you've built, where even if you don't have the answer, you would say to yourself, oh, that might be an issue, that might be a thing, but I know who to call.
Yes, exactly. And that's kind of the theme of the show. It's the advice that I really want to give the audience is seek expert advice. Really important. Like build your team with people that know what they're doing. Don't hire jack of all trades. Hire people who, you need a loan, call Mona. You need an eviction, call somebody who does unlawful detainers, right? So that's the point. The point is you gotta work with people who stay in their lane, who are focused, and who do just that. That is so important. And I think that over the years, as you specialize more and more, it becomes extremely important for to kind of get a full picture of building the best possible team.
I agree. Well, I wanted to thank you again for your time.
Absolutely, it's a pleasure.
You're clearly an expert in what you do.
Thank you. Yeah, and I love sharing my knowledge. And as I said, if anybody has any questions, please feel free to reach out.
All right. I'll see you later. Bye.
Bye.
Bye.